and welcome to Law Weekly. I'm Shola Shayeli. On Wednesday, the National Assembly re-amended the Electoral Act Amendment Bill and approved both direct and indirect primaries. Both chambers made the re-amendments in separate plenary sessions. In the Senate, the lawmakers also added the consensus clause for the nomination of candidates by political parties for elective positions. But at the House of Representatives, the legislators removed the consensus option. This move is the latest in the series of events that have trailed President Muhammadu Buhari's decline of assent to the bill, and it's the starting point of my conversation with Senior Advocate of Nigeria, Yemi Candid Johnson.
What is fundamental to any electoral regulation is guaranteeing its integrity. We have seen from the manipulations, from criminal activity committed in elections in the past, that Nigerian elections by and large lack credibility. To restore credibility of elections is important because the legitimacy of the government that is produced by elections depends on people's confidence in the process by which those elections were conducted. So anytime you want to modify electoral law, the purpose is not about a single item, but across the board, the integrity of the process, the capacity of the electoral umpire, the mechanisms for counting the vote. What is an election? It is a test of the popular will. Therefore, anything that makes it easier to decide what that will is genuinely and to reduce the opportunity for manipulation of fraud, which over the years in Nigeria, since this new democracy has been manifest and multiple. Anyone who's been involved in election petitions will tell you the roadmap to rigging elections, suppression of votes, cancelling elections, double entries, fingerprinting. So there are many methods by which you can rectify that. You learn from your mistakes. Technology, means of vote counting, access, location of the polling units, identifying them, voter access, voter registration, voter accreditation. There's a variety of means. But we seem to have fallen in this last exercise on the question of indirect primaries. This seems to me to be the smallest aspect of the Electoral Act. At the end of the day, international best practices would require that parties by themselves determine the method by which their candidates are chosen and not the National Assembly. So I have no difficulty with National Assembly taking that out if it became controversial. I don't know the reason why the president doesn't want it. I don't know whether it's party political, whether it's logistical, whether it's genuine. But what I know is that there are a number of reforms in the Electoral Act which would improve the product of our elections. And I would be happy to have those ones pursued, even if one single aspect, indirect primaries, is removed.
So you say that is a small part
as far as I'm concerned. Improving the regulation by technology, card readers, for example, the ability to identify genuine voters, and the ability to be able to check people's data and biometrics against the exercise of voting, which is a big thing. In many parts of this country, people who are not on the ballot vote, people who have no registered cards. I myself am waiting for my new card from INEC. The last election, I was told that I was not registered, even though I'd voted the same polling booth with the same card in the previous election. Someone joked that my vote may have been used somewhere in Newi or in Abakaliki, who knows. But I've gone back to INEC and asked them to reissue my card, and I'm still waiting for it. What's so complicated about issuing a card? My bank can issue me a new bank card within 30 minutes. And these are things which are problematic in conducting elections because voter suppression starts a long time before the elections. Taking away your right to vote through not giving you the right card, not putting your details on. Imagine I voted in every election in this country since I was old enough to vote, and the INEC site says my details are not on their site. As far as I'm concerned, the corruption of the voters register is itself an act of corruption, and it's a means to manipulate the vote.
These are the bigger issues.
These are the big issues in the Electoral Act. And there are a lot of issues. People who I'm involved in, lots of smart young people have studied the Electoral Act. They have come up with a lot of proposals for improving its efficiency and the legitimacy of the outcome. And I think that a lot of those changes have been implemented in the Act. So I'm delighted that it'll be passed, even if that aspect is removed.
Let's come back to the judiciary. You know, like when we're talking about the Electoral Act and elections generally, you talked about the problems that have always been there. Coming back to the judiciary, there are also some problems that they're recurring in the judiciary. You talk about inadequate court infrastructure, you talk about appointment of judges. We're also seeing, as we're going into the election year, we're starting to see conflicting court judgments, so much so that it became an issue and the NJC didn't even have to wait for petitions to start addressing those issues. Why does it seem like the issues in the judiciary, exit from the judiciary, entry, access to justice, the speed of justice, why does it seem like all these issues continue to plague the judiciary?
You know, I'm glad you mentioned the judiciary right after we speak about election practices, because the judiciary is very often the crown on election malpractice, because the standard for investigating and regulating elections on petitions is substantial compliance with the electoral law. Now, what is substantial compliance? There are a variety of definitions that the judges have given, but I would have thought that the simplest one is that they should ask themselves whether the election as conducted has captured the will of the people. That's simple enough, because if it hasn't, it cannot be substantial compliance. But we multiply words and we multiply concepts, and there's a whole degree of electoral case law which has been developed, which has made challenges to elections very technical and very inept. This is what allows judges to provide the seal for corruption in elections by awarding elections to whoever they choose. So I'll give you an example. We have an election in which I was involved in an election petition, where the electoral body produced a voter return which said 253 people were accredited, but 300 people voted. So on the face of that, that is a false and fraudulent document. But the electoral case law says to falsify an election return, you must produce the genuine return. So the only way you can do that is to prove that they wrote something that was right and then they wrote something that was wrong. But if on the face of what they gave to you, it's wrong, it's not tenable. Another example, the electoral body says we did not conduct elections in polling units 15 and 16. So on their own testimony, there was no election there. That is a bad election. And the court says, according to the jurisprudence, to prove there was no voting in a particular polling unit, you must produce a voter who didn't vote there, who was disenfranchised.
Even when they themselves have admitted that it didn't conduct.
It sounds stupid because it is. But there's a whole series of decisions. And you see, so the judges are considering electoral law and formulating it on the assumption that it's a technical issue when the only issue is whether the will of the people has been expressed. So I think that the fundamental problem, to answer your question very simply, is that many of the judges, and I think that the large majority of those who operate our judicial system, not individual judges, but those who are in the heights of the judiciary, think it's a game. They think it's a theater, and that the importance is their dress, the fancy dress, the 17th century English horsehair wig, calling you honorable, my honor, my judge. These are public servants paid from the public purse to deliver a public service which is the due, proper, and efficient administration of justice. If they know that that's their function, many things will fall into place. Because you can, the problems we have, someone was talking to me this morning about the docket control in the Supreme Court of Nigeria. It is more than anecdotal that you cannot list a case in the Supreme Court without a corrupt intervention in the registry of the Supreme Court. Which means that the foundation of the decisions the judges will give is already undermined. And they can regulate this. This is a matter of simple administration. You go to the Supreme Court, you sit down there for 6 hours, the court don't hear a single case because they're dealing with procedural and technical matters, because they're dealing with questions of substitute service, they're dealing with questions of stay of proceedings. I was telling somebody, we have cases in Nigeria on stay of proceedings. The last significant case on stay of proceedings in England is 1878. It's an irrelevant issue to the merits. The job of the judge is to decide the merits of a case, not to indulge himself in the idle fancy of procedure. And they say it every time, we won't be obsessed by technicality, but they are. The instinctive response of most Nigerian judges, especially in the appellate courts, is technicality. I understand they have a burden of work, but if you organize the administration properly, you reduce the type of cases you grant leave for, you reduce the number of cases which are allowed to come to the higher courts, you end cases at a lower court and diminish the right of appeal, you will have opportunity to decide the policy of law, which is the job of the appellate courts.
I want to go back to something that you said about technicality. Supreme Court being preoccupied with technicality instead of looking at the merits of the case. I saw that you wrote an article about the Supreme Court decision that the EFCC no longer has the right to arrest or prosecute any state government after their tenure. I don't know, this judgment, I had several interpretations from several lawyers. Did you see the judgment? Did they really say this?
No, I think that two things. There seem to be a number of judgments that were given out, and some of them have not been released to the public. The main decision seems to be the case of Nwobiken, and these headlines are interpretations of that judgment. Of course, Nwobiken is not a governor, but the point I think that the court was making there is that the Economic and Financial Crimes Commission has a limited statutory mandate, and it should fulfill its mandate. Many of the cases which are being pursued by EFCC, for one reason or the other, some of these reasons are purely political rather than legal, or to vindicate the criminal law or public prosecution. And many of these cases are not really their business, but then they're the business of the ordinary police. They've filled the vacuum where the ordinary police seems unable. The ordinary police is largely occupied with protecting official and unofficial VIPs. You know, you can get more police around an ex-wife of a public official than you can get in a police station. So this is a fact. So basically, the EFCC exceeded its mandate, and most often for malign purposes. I think that nobody who has dealt with the EFCC will deny that many of those cases are either primed to fail or are intended to be dragged on as vehicles for commercial advantage. Many banks have cases which are being pursued for them by the EFCC. The conditions on which those are being done would bear investigation. Somebody should be investigating EFCC itself. It's a good thing I have no financial crime.
But I'm just wondering, where does this judgment leave us? Because we've just admitted that the police is hampered by doing some other things and not pursuing the cases that they should have done.
Yes.
I would have thought that, well, as long as a crime has been committed, the courts, it will still come back to the courts anyway, whether it's the police who is prosecuting or the EFCC.
That's an ordinary man's thinking. You're right. So in the case of Nwobiken, it would appear that a person who is morally culpable has escaped justice. To the ordinary man on the street, it would seem like some big cat has escaped the net of law, but then some small guy who took 3 loaves of bread is going to go to jail. That level of disparity in the application of justice destroys the credibility of the system across the board.
I'm aware that on the 25th of this month, the National Judicial Council, the NBA, and I think the Justice Research Institute will be holding a Justice Summit to deliberate on reforms necessary for the judiciary.
I've seen the notices.
Yes. And I'm just wondering, with all the myriad of problems that we've talked about that are challenging the judiciary, what are those things, maybe 2, 3, 4, that it could focus on in the short term that would give us that quick reform, fast reforms that we need to make the justice system work more effectively?
One of the biggest problems with courts is delay. The delay is generally caused by lawyers not preparing in advance of cases. You can proceduralize access to courts and not allow access unless the procedures are met. So for example, you have pre-action protocols. If you realize that 80% of land cases are delayed because there's no survey plan, you cannot file a case without a survey plan. That proceduralization immediately cuts some cases out. Interlocutory motions. 80% of the court's time is on interlocutory applications. These should be resolved in chambers. They should be resolved by paper. You don't need to go to court and stand up to take most of these motions. The purpose of coming to a court should be for trial. There should be zero tolerance for lawyer dilatoriness and delay and lawyer incompetence, and the ethical responsibility of lawyers should be enforced by fines and by threat to their licenses for misconduct. In the appellate courts, the access to the court should be limited. Leave to appeal should be almost always refused. There should be no leave to be granted for interlocutory applications. The number of interlocutory applications in the highest courts is a complete waste of time. The Supreme Court and Court of Appeal should only empanel to hear the merits of substantive cases on serious questions of law. Once you appeal out of time, you have lost your right of appeal. It's a discretionary bar. That bar should come down like a hammer. Because if you force the lawyers to work, they will reduce the work that the judges are doing. If the judges have less work to do, they will do it better. I think that's 5 points.